Good morning, everyone. My name is Kathy Purdy. I am a marketing manager with Schoeneck King, and I'd like to welcome you to our spring 2021 virtual breakfast briefing. Hard to believe it's year two that we've done this. Today's presenter is Kate McClung. She is a member of our labor and employment practice out of our Rochester office. I just want to cover two quick housekeeping items before we get started. Please submit your questions through the Q&A box, which is located at the bottom of your screen, and Kate will do her best to address those as time allows. If you would take a moment to complete the survey once the webinar has ended, we would appreciate that, and I will share your comments and suggestions with Kate. This program has been approved for 1.5 HRCI and SHRM recertification credits, and we will get those certificates out to you no later than the end of day tomorrow. So again, thank you for joining us, and I'm going to hand our program over to Kate.
Great. Thank you so much, Kathy. Okay, thanks everyone for joining this morning. We do anticipate a lot of things on the horizon as far as employment law is concerned. So we wanted to take this morning to go over some of those changes so you could anticipate what's coming. So we're going to start off by talking about changes to EEO laws and policies, wage and hour developments, OSHA initiatives, and potential union organizing and NLRB developments. And some of those NLRB developments affect non-union employers as well as union employers. And throughout today's presentation, I'm going to talk both about changes that we see on the horizon and some things that have already happened in the very short period of time under this new administration. So during the campaign, Biden referred to himself as the strongest labor president that you've ever had. And I wanted to start this morning's presentation by talking about some of the things that Biden has stated, either during the campaign or during the early days of his administration. So he said, I want you to know I'm a union guy. Unions are going to have increased power. He said everything that defines what it means to live a good life is because of workers who organized unions, that there's a war on organized collective bargaining agreements, unions and workers, causing rising income inequality, stagnant real wages, loss of pensions, exploitation of workers, and a weakening of workers' voices in our societies. So clearly very strong views on union issues. We're going to talk about that certainly at the end of today's presentation. He's also said that we could survive without Wall Street and investment banks, that employers steal about $15 billion a year from working people, that workers experience huge losses in salary caused by other forms of wage theft, like employers not paying overtime, forcing off the clock work and misclassifying workers. Employers repeatedly interfere with workers' efforts to organize and collectively bargain. In nearly all union organizing efforts, corporations run a campaign against the union. So some pretty one-sided statements here, very pro-employee, very in favor of strong protections in terms of workers' wages. He's talked a lot about misclassifying workers, so we can expect to see some changes, maybe some narrowing in who can be exempt from overtime, some narrowing in who can be classified as an independent contractor as opposed to an employer, some increased overtime allowances. These are all things that we're going to talk about today as well. He's also stated certain plans in his policy documents during his campaign. He said he wants to make it easier for workers who choose to unionize to do so, to establish a national ban on right to work laws. And those, are, the name's a little bit misleading. Those are the laws that restrict unions from requiring dues from all employees. So this is actually a very pro-union plan to establish a ban on those laws. Create a cabinet level work group to focus on promoting union organizing, to increase the federal minimum wage to $15 per hour. Remember, it's just $7.25 right now, which, in New York sounds so low because our minimum wage is already so much higher. But for those of you who have employees in other states that don't have a high minimum wage already, like New York, that's a sizable jump. That's more than double what you may be currently paying minimum wage employees. And expand workers who are eligible for overtime pay. So clearly a lot of very pro-employee plans, a lot of things that may have a very significant impact on your business. So we're going to start off by talking about EEO laws and policy changes. We're going to talk about potential changes at the Office of Federal Contract Compliance Programs for those of you who are federal contractors. We're going to talk about an increased emphasis on pay equity. That's definitely something that we see on the horizon. We're going to talk about potential amendments to the Age Discrimination and Employment Act, as well as enforcement priorities at the EEOC. So let's talk about the OCFFP. So the Biden administration has already been walking back policy initiatives established under the Trump administration. One example of this is Executive Order 13950. This was signed by Trump just in September, just a few months before the election, and it was going to apply to contracts that were executed on and after November 21st of 2020. And this, the stated purpose was to combat offensive and anti-American race and sex stereotyping and scapegoating. And it didn't prohibit training, but it really restricted the content of what you could have in your anti-harassment, anti-discrimination training. For example, under this executive orders, federal contractors couldn't say that the United States is fundamentally racist or sexist or has systematic racism. You couldn't say that the meritocracy, any meritocracy system was created by a particular race to oppress another race. You couldn't say that an individual should feel discomfort or guilt based on their race or sex. And so this executive order really raised a lot of questions about whether it was permissible for federal contractors to conduct any sort of implicit or unconscious bias training, which is something that we've been seeing a lot more of, and that a lot of people think is very helpful in the workplace because, hopefully we're at the point where we've started declining in intentional harassment and intentional discrimination. And maybe more of the problem lies still with the unconscious harassment or discrimination, where someone's not meaning to offend, but does in fact cause offense because of their implicit stereotypes or bias. And so that's the type of training we've really seen a lot more of. And a lot of people perceived this executive order as prohibiting that sort of training. But one of the first things Biden did when he took office was he revoked that executive order on January 21st. So as of that date, this executive order is no longer in effect, no longer applies. So it really was only in effect for about 2 months. It's a very narrow applicability. Another thing Biden did was he signed Executive Order 13985, which seeks to advance equity and remedy discrimination. There's a lot of different components to this executive order. The stated purpose is that he wants to establish a comprehensive approach to advancing equity for all. And this will include efforts to remove systematic barriers and provide equal access to opportunities and benefits provided by the federal government. It also states that the government will identify communities that it has historically underserved and develop policies designed to advance equity for those communities. It calls for equity assessments across a lot of different segments of the federal government and calls for the creation of an interagency working group to compile and analyze equitable data. So we'll see what comes out of that. Still very early days for that. Another thing that Biden did pretty quickly was rescind Trump's expansion of the religious exemption. So one thing that Trump did was broaden the exemption available to federal contractors and subcontractors to help them avoid liability for discrimination claims that stemmed from employment decisions that were made consistent with a sincerely held religious belief. And so he made that exception pretty broad. And so that was a pretty controversial decision at the time. There were a lot of legal challenges brought to that in court. And the OCFFP under Biden has moved for a stay of all of those cases, stating that it intends to seek a rescission of that rule that the Trump administration put into place. So a lot of things going on for those of you who are federal contractors or subcontractors. There's also stated plans to really increase emphasis on pay equity. There's still a significant wage gap between men and women. There's also wage gaps based on other protected categories as well, such as race is a good example of another one. And this seems to be a major agenda item for the Biden administration. Vice President Harris has expressly stated on numerous occasions that she wants the United States to be a leader in this area. There is a bill that's pending in Congress. It hasn't been enacted into law yet. It hasn't been signed by Biden, but it's called the Paycheck Fairness Act of 2021. And that's aimed at strengthening protection against gender-based pay disparities. So the current law, many of you are probably aware, is the Federal Equal Pay Act. And this just addresses equal pay based on sex. And there is a defense built into that law that employers can rely on if a claim is brought against them. So if a woman brings a claim and says, my male coworker is in a similar position to me, but he's making more money, the employer can defend that claim and win by pointing to a bona fide factor other than sex that explains the pay disparity. So some examples of bona fide factors may be different levels of training, different levels of certification or degrees, different years of experience, different number of years at the company, different educational degrees. So, there's a number of examples that employers can rely on to defend those types of claims. But the Paycheck Fairness Act would make that defense much more narrow and would make it more difficult for employers to defend against pay equity claims. So employers would have to demonstrate that the pay differential is not based on sex. And rather than pointing to just having to prove a bona fide factor, you actually have to prove that the factor that explains the pay differential is job related and consistent with business necessity and accounts for the entire difference in pay, which is something that may be very difficult for many employers to prove, especially if they don't have a really robust salary grade system and really objective factors that determine where employees fall within that salary grade. For your New York employees, keep in mind that we do have a New York Equal Pay Act as well, which is actually much broader than the Federal Equal Pay Act. That has a similarly narrow defense to it. So the federal change may not impact your New York employees so much because they still have a much broader right under the state Equal Pay Act. But for any employees you have outside of New York that aren't subject to a broad state level Equal Pay Act, this could be a very significant change for you. Also keep in mind that the New York Equal Pay Act isn't just sex-based differences. It requires equal pay based on any protected category under the human rights law. So that's something that, again, we've been seeing more and more claims on since that passed a couple of years ago. Okay. So with all of this happening with this Paycheck Fairness Act, potentially being passed through Congress and with our very broad New York Equal Pay Act, if you haven't done a pay equity audit in the last few years, that's something that you may want to consider doing. The penalties under the state law in particular are very broad. For those of you who have had the unfortunate distinction of having to deal with a wage claim under the labor law, you may know that the penalty under that law is that you have to pay any back wages owed plus an 100% penalty. So if you owed someone $5,000, you have to pay them that $5,000 plus another $5,000 as a penalty, plus interest and attorney's fees, which can add a lot to it as well. The Equal Pay Act, though, requires that you not only pay the wages due, the differential, if it's found that there was a differential based on sex or based on another protected category, but instead of the 100% liquidated damages penalty, there's actually a 300% liquidated damages penalty. So these cases can be quite expensive if you're found to have paid employees differently based on a protected category. Some other things that the Paycheck Fairness Act includes is it makes it unlawful for employers to prohibit employees from discussing and disclosing wages. There are already similar protections for any covered employees under the National Labor Relations Act. And we also have a statute in New York, as I'm sure you know, that was passed a few years ago, that also contains limitations on requiring employers to prevent employees from discussing and disclosing wages, as well as this next bullet point, prohibiting employers from relying on salary history in determining starting wages. That's something that we already have in New York, but again, for any of your employees outside of New York, that might be something new for you. And this is the policy reason behind this provision is some experts in the field have opined that if women are already being paid less and future employers are considering salary history and determining your starting wages, that just perpetuates the wage gap for women. Whereas if that's not a factor in the decision making for starting salary, then in theory, that should help eliminate the wage gap. There's also protection against retaliation in the Paycheck Fairness Act for making complaints, and it increases the penalties as well. Okay, so that's equal pay. That's something that we see as fairly likely to happen. Another wage and hour change that we might see in the horizon is the revitalization of the EEO1 component 2 data. For those of you who are subject to these reporting requirements, I'm sure you're well aware of the history here of the Obama administration wanting to expand component 2 data to collect gender, race, and job category wages by employees. This is, of course, required for employers with 100 plus employees and federal contractors with 50 plus employees. But under the Trump administration, the EEOC announced that it wouldn't seek to collect that data starting with the 2019 collection cycle. However, we do anticipate the Biden administration to shift back on that, especially given their increased focus on pay equity. It's also possible that they may expand that and require even more detailed data. So that brings us to the Age Discrimination in Employment Act. The current standard for causation is but for. So if someone brings an age discrimination claim against your company, it's their burden of proof to demonstrate that but for their age, they wouldn't have experienced the adverse action, like the termination, being passed over for a promotion, not getting a raise, whatever the adverse action is, they have to prove that but for their age, it wouldn't have happened. And that's a pretty high standard to meet. That can be difficult for employees to meet. There is some thought that the Biden administration may seek legislation to change that and make it a motivating cause factor. And that's similar to the standard under Title VII. So they would just need to show that age was one of the factors that led to the adverse action, not the but for factor, not what, pushed it over the edge. So it would make it easier for employees to prevail on age discrimination claims. Okay, so some other goings on at the EEOC. Charlotte Burrows is the new EEOC chair. She was designated by President Biden on January 20th, and her current term ends in 2023. She's very qualified for the position. She's considered to be a liberal chair. But remember, the EEOC is on a commission basis, and there's 5 members of the commission. And so while the chair has a lot of power over certain individual decisions within the agency on a day-to-day basis, any big significant changes have to be approved by the commission itself. And the current makeup of the commission is 3 Republicans, 2 Democrats. The earliest Republican term who's expiring first isn't until July 2022, at which point Biden will almost certainly select a Democrat, and then we'll have a 3-2 Democrat majority. So we don't really expect to see any significant changes until that point in time on an agency-wide basis. But again, the chair does have a lot of power to make smaller changes within the agency. Another thing that happened that was a bit surprising was the EEOC general counsel was terminated in early March after she refused to step down. There's already legal challenges to that. It's unclear whether or not it's legal or not. For Biden, whether or not Biden has the power to terminate the EEOC general counsel. There's some debate about whether this is an independent standalone commission or whether her post serves at the pleasure of the president and he has the power to terminate her. Her Senate confirmed term was set to run until 2023. So we'll have to see whether or not there's any successful challenges to that. She was a Trump appointee, and a Republican as well. So as I mentioned, there will be a Republican majority until 2022. And here, the current strategic enforcement plan is in effect until 2021. Here's some examples of what's in that plan. Eliminating barriers in recruitment and hiring, protecting vulnerable workers, including immigrants and migrants, and from underserved communities, addressing selected emerging and developing issues, ensuring equal pay, preserving access to the legal system, and preventing systematic harassment. So we'll certainly expect to see cases that they're selecting for litigation to continue to be driven by the current enforcement plan. But some pending matters that we'll see what comes out of the EEOC, and these are examples of where the chair could have a lot of power in shaping the course of where the EEOC is going. Throughout COVID-19, the EEOC's continued to update their guidance. So, for example, a couple months ago, they updated it to address vaccination issues because all of a sudden we had these vaccines approved, and everyone had all these questions about, okay, well, what can the company provide the vaccine to employees? If so, what questions can I ask? Are there any disability issues there? There's also questions about wellness incentives. Can I offer incentives for my employees to get these vaccines? And that's something that they may issue regulations on or may issue more detailed guidance on. Also, religious enforcement. What if I'm requiring employees to get the vaccine, but someone says they can't because of their sincerely held religious belief? What are my options there? Can I require them to get the vaccine anyways? Can I prevent them from coming into the workplace? So these are all, fairly new and novel issues that we expect to see more guidance from the EEOC going forward. Some enforcement priorities that we expect from the EEOC under the Biden administration. He stated that he promises to empower the EEOC, so they may get more money, more resources that may enable them to bring more litigation. As I'm sure many of you have experienced an EEOC charge in the past, I suspect very few of you have experienced being sued by the EEOC in court because the EEOC selects a pretty small percentage of cases filed before it to go to litigation, but we may see an increase in that. With the pay equity data collection, as I mentioned, we may see the reinitiation of the collection of component 2 data and maybe even an expansion of that. Systematic bias prevention, we've already seen for federal contractors, Biden revoke the executive order that called into question whether or not you could do training on that. There may be other initiatives to promote that, especially with his new executive order to promote equity across all branches of the federal government. LGBTQ discrimination and harassment. This shouldn't have a big impact in New York because that was already something that was illegal under New York law, but under federal law, it was a very recent Supreme Court case that held that this category is protected under Title VII under the sex category. And so we may see the EEOC focus a lot of resources on that. And sexual harassment prevention, with the expansion of the Me Too movement, we've seen a lot of efforts focused on sexual harassment, both at the state level, and I think we'll see that more and more at the federal level under this new administration. Okay, so that's everything on EEO. I'm just going to take a quick look at the question and answers. I have one question so far. Are we going to cover the upcoming marijuana change? No, not today. Today's presentation is focused on changes under federal law, but we did do a pop-up webinar for clients on the upcoming marijuana change on that issue. So if you want to email me afterwards, I can get you those slides. Okay, wage and hour changes. Here we're going to talk about the federal minimum wage and what we see is likely to happen there, joint employer rules and independent contractor rules, as well as exempt employees and salary minimums. So let's start with the minimum wage. So as I mentioned, the current minimum wage is just $7.25 an hour, which is significantly below anywhere what it is in any region of New York. It hasn't been increased since 2009. Obviously, I mentioned that New York has a higher minimum wage. Employers are always entitled to whatever the highest minimum wage is that's applicable to them, whether it's the state, as it is in New York, or the federal. And in New York, I don't know if I hope you can see this. It's a little bit small, but we put in a chart showing what the minimum wage is in each region in New York. It's important to remember, if you have minimum wage employees who work at different locations within the state, you do have to pay them based on where the work's actually performed, not on where they work most of the time, not on where they're based. So there is proposed federal legislation. Again, this hasn't been passed yet. It's not currently law, but it would raise the federal minimum wage to $15 per hour over a period of several years. And 2025 is when it would hit 15, assuming this gets passed. The most significant wage increase is in the very first year. It would increase it to $9.50 an hour. So that's an increase of $2.25, which is almost it's about a 35% increase. So that's quite a boost in your paycheck that first year. There is question, though, about the viability of the statute. It's unclear if it has enough support in the Senate to pass. And we've seen a lot in the news about whether the Democrats are going to eliminate the filibuster altogether. It's been called the nuclear option. And then they would be able to pass legislation with just all the Democrat votes plus Vice President Harris as the 51st and deciding vote. But that's something that we're just going to have to wait and see on. There was a push to get the minimum wage increased in the last COVID relief bill, and that ended up getting taken out because there were a few Democrats who were somewhat resistant to it, which again, even if they do eliminate the filibuster, there's still some question about whether or not they could get all 50 Democrats to vote for it. But here's the schedule of the proposed wage increases. There is included with it, there is an indexing adjustment. So each year, the indexing adjustment would make the minimum wage equal to the previous year's value, plus the annual percentage increase in any of the median hourly wage of all employees. So it is possible these numbers could somewhat change over time based on inflation. The joint employer rules is something that we've seen a lot of back and forth on under different administrations. But the general concept is, when is more than one entity considered the employer of an employee? And we see this a lot in a couple different contexts. So one context we see this a lot is with temp agencies. And if the employee was discriminated against, if the employee wasn't paid correctly, often that employee will sue both the temp agency and the entity that was using his work through the temp agency, regardless of which entity was actually listed on the person's paycheck, was providing the W-2s to that person will sue both and say, well, you both employed me, you both controlled my employment. And there are a number of circumstances where numerous entities can be liable, including for FLSA liability. Some other places where we see this is where an entity where there's multiple related entities. So you may have a company and you may have a holding company, and then there may be 20 affiliates that are subsidiaries of that holding company. And sometimes people claim that they were really jointly employed by multiple related entities, a parent and a subsidiary, two affiliates. We also see this in the franchise context, where an employee will bring claims both against the franchisee and the franchisor. We see this in the context where someone's employed by an entity and the person who owns that entity or is a major shareholder in that entity also owns another entity. And that person may claim, well, I was really employed by both entities. So there's a lot of contexts where this can arise. So in March of last year, the US Department of Labor issued a final rule regarding joint employer status, and they adopted a 4-part test assessing when an entity is a joint employer. So they looked at hiring and firing tests, who had the power to hire and fire the employee, who supervised and controlled the employee's work or schedule in a substantial way, who determined the rate of pay or the method of compensation, and who maintained the employee's personnel records. It's a balancing test, and no single factor is determinative of the outcome. You really have to look at all the factors. And if multiple entities are found to be joint employers, then they're all responsible for the entire amount of the wages. It's called joint and several liability. So let's say an employee sued 2 entities, they were found to be joint employers, and a judgment was awarded of $50,000. The employee could try to collect that against either of the entities, both the entities. So either of those entities could be on the hook. If you hired that employee from a temp agency and the temp agency has since gone out of business, well, the employee is going to come after you for the full $50,000. And if you're found to be a joint employer, you would be on the hook and would have to pay that full $50,000. This final rule was successfully challenged in federal court by 17 states and the District of Columbia. The court vacated the rule's substantive provisions, and the U.S. Department of Labor appealed that decision. Then, while that appeal was pending, the Biden administration came in, and the U.S. Department of Labor, under the new administration, sent a new proposed rule to the White House for regulatory review, and expected that changes are going to be made to the joint employer rule. It's expected that, the rule that had been passed was a narrowing of the rule that a lot of courts had been applying. And so it was a much more pro-employer rule. We do expect that the new rule is going to be much more pro-employee and is going to take a much broader approach to joint employees. The U.S. Department of Labor announced its intent to rescind the prior regulations, and the comment period for that is still ongoing. That ends April 12th, if you're interested in submitting any comments to the U.S. Department of Labor on that decision. They stated that the rescission was prompted in part by the court decision in the case that was brought by the states in the District of Columbia. Some similar things going on with independent contractors as well. On January 7th, the U.S. Department of Labor finalized a new independent contractor rule. The stated intent was to provide employers with as much clarity as possible with respect to classifications. With joint employers and independent contractors, historically, it's always been these multi-factor tests with, 10 different factors, and it's a balancing test. So it was really difficult to predict up front what a court would actually hold if it looked at the classifications, because they were pretty subjective tests. But in the last days of the Trump administration, they finalized this new rule, reaffirming it as an economic realities test. Is the individual in business for themselves, or are they economically dependent on someone else for work? It limited the factors that should be considered quite significantly to just 5 factors. There were 2 core factors. The nature and degree of control over the work. Was the individual really in control, or was the company in control? The worker's opportunity for profit and loss. Obviously, if they have the opportunity to profit or suffer a loss, then that really is more indicative that they're in business for themselves rather than an employee. And in addition to those 2 core factors, they identified 3 additional factors that would be given less weight, but would still be considered. So the amount of skill required for the work, the degree of permanence of the working relationship between the employer, potential employer, and the worker, and whether the work is part of an integrated unit of production. So this was really going to be an examination of the workers' actual day-to-day practices, the economic reality of their work. But this rule was supposed to take effect on March 8th, and on March 4th, under President Biden, the U.S. Department of Labor issued a notice delaying the effective date until May 7th. And then just 1 week later, they announced a notice of proposed rulemaking to rescind the rule altogether. And the comment period for that also ends April 12th. The reason given for the rescission was that it would narrow and minimize other factors considered by courts traditionally, that longer list of factors that I mentioned, which makes it much harder to predict how a court's going to come out on a classification issue. And so that's another change that's happened under Biden. Okay, so that brings us to exempt employees in the salary minimum. So the current federal minimum salary threshold is $684 per week for executive, administrative, and professional exempt employees, the so-called white collar exemptions. In New York, as with minimum wage, the minimum salary threshold is higher. Here's in red what it currently is for quote unquote upstate, for Nassau, Suffolk, and Westchester counties, and for New York City, which is split between large employers and small employers. Small employers being those with 10 or fewer employees, and large employers being those with 11 or more employees. So obviously the New York level is much higher, but the New York level, keep in mind, doesn't apply to professional exempt employees, only to executive and administrative. So if you have any professional exempt employees, you can still pay them the salary level based on the federal, because there is no salary level requirement under the state. Just a quick reminder, the salary is not determinative in deciding whether or not an employee meets and qualifies for any of these exemptions. They have to meet the duties test as well. So even if you're paying them that salary level week to week, if they don't meet the duties test, you could be found guilty of an overtime violation. Also in New York, with these different regions, as with minimum wage, and this is a much more common issue for salary than for minimum wage, because your exempt employees are much more likely to travel and be working in different locations in the state. It is based on where they're actually working. So if you send an exempt employee down to a conference in New York City, you would actually need to make sure that you pay them the New York City salary level for that week. Okay, we do see, based on comments made by the new administration, a potential increase in FLSA salary minimums for exempt employees. In 2016, the Obama administration, as I'm sure everyone who was in HR at the time remembers, tried to increase the salary level to $913 a week. We did a lot of work. We got all ready to implement these changes. And then at the last minute, a court, put it on hold, and it ended up being withdrawn by the administration. So when the Trump administration came in, and so there was, I think a lot of companies still went ahead with the increases. A lot of companies decided not to go ahead with the increases, but, it was a lot of work all up until this very dramatic last minute hold on implementing the new rule. But Biden has expressed his goal to expand the availability of overtime and increase individuals' real wages, which could mean exempt salaried employees as well. Especially with minimum wage being increased more than double, assuming that gets passed, I think it would be difficult for the federal government not to also increase the salary level without, starting to create real wage compression issues within the entity. Okay, so moving on to OSHA. It looks like I don't have any questions at this point, so I'm going to press forward. We're going to talk about OSHA enforcement priorities and OSHA standards and policy statements. The Biden administration has expressed interest in more enforcement action from OSHA, so it may be that, as with the EEOC, they may designate additional resources to OSHA for enforcement actions as well. We've already seen an uptick in COVID-19 related OSHA violations. And I think that's something that the new administration has indicated is going to be a big enforcement priority for it. On January 21st, Biden issued an executive order on protecting worker health and safety. This indicates that there should be a continued emphasis on preventing workers from contracting COVID in the workplace. It's called for the launch of a national program to focus on OSHA enforcement efforts for COVID-19 related violations. And they instructed OSHA to consider the need for emergency temporary standards on COVID-19 by March 15th, 2021. And we haven't seen those yet, so those are a bit late. But they did also call for revised OSHA guidance, which doesn't need to go through quite as lengthy a process, and so that has been issued. That was issued in late January. It didn't create, though, any new standards or legal obligations, interestingly. It largely reiterated prior COVID-19 guidance, but it does emphasize the importance of employee education and that education has to be in an understandable language. So for those of you with employees who have languages other than English as their primary language, that's something that you need to factor in doing safety trainings. It also indicates that employees have to continue to engage in proper safety protocols, including social distancing, hand washing, face coverings, barriers, isolation of symptomatic employees, proper cleaning, disinfecting surfaces, common touch points, high traffic areas, etc. And it also indicates that when implementing and enforcing safety protocols, employers can't differentiate between employees who are fully vaccinated versus those who have not been vaccinated or are only partially vaccinated, and emphasizes that all employees, regardless of their vaccination status, should continue to abide by the safety protocols for now. Even though this is only guidance and not regulations, it is important to be compliant with it, because if you're not compliant, that could be the basis for a general duties clause violation, that employers have a general duty to provide a safe workplace. The OSHA National Emphasis Program is a new enforcement program specifically aimed at COVID-19 violations. It's focusing the agency's resource in critical injuries until further notice. And the purpose is to ensure that employees in high hazard injuries are protected from COVID-19. What we've seen so far is that this program intends to target specific high-risk industries. And we'll talk about what those are in a moment. It also has retaliation prevention efforts, which contemplates distributing anti-retaliation information to employees during inspections and pursuing other outreach opportunities to ensure that employees understand their rights under OSHA and understand that they can't be retaliated against for making a complaint. So as far as the targeted industries of this program, there's two big categories. There's the primary targets and the secondary targets. Some examples, it would be too lengthy to list them all, but some examples of the primary target industries include healthcare, meat processing, grocery stores, restaurants, both full and limited service, general warehouses, and correctional institutions. It also includes temporary health services, where employees are working for different employers in short periods of time. So none of these should be that surprising. I think throughout COVID-19, we've seen these are a lot of the industries we've seen a lot in the news. I mean, meat processing, there was a whole period of time where it was unclear whether we'd still be able to get meat for the foreseeable future. Obviously, healthcare, it's an obvious one. Grocery stores and restaurants we've seen a lot about. Prisons we've seen a lot about. Secondary targets, some examples that may apply to some of you include construction and various types of manufacturing. There's also some very specific ones like agriculture and fishing, nurseries, garden and farm centers, bus transportation. So, if you think you might be an industry that's been targeted, you can confirm on the OSHA website as well. Okay, some notable recent OSHA enforcement is they did cite an auto parts manufacturer in February of 2021 for failing to implement and enforce protections from COVID-19. Specifically, workers were often working within 2 feet of each other for hours at a time and weren't consistently wearing protective face coverings. And so they were cited under OSHA's general duty clause for 1 serious violation and 2 what are called other than serious violations. Specifically, 2 operators tested positive. One of the operators fell ill as a result and later died. And OSHA did make the determination with a quote reasonable degree of medical certainty that the deceased operator contracted the virus on the job. Now, obviously, getting the OSHA citation in itself isn't great, but with that OSHA determination, that would also really strengthen the employee's workers' comp claim. The workers' estate's workers' comp claim because the worker has deceased, and so that could be a very expensive liability on top of the OSHA citation. Okay, so I don't see any questions, so we're gonna move forward to our last topic of the day. Usually when we do these live, I usually work in a 5-10 minute break, but I think today we're just gonna press on and see if we can end a little bit early or have extra time for questions if there's questions at the end. So our last topic for today is potential union organizing and NLRB developments. As I mentioned at the outset, some of these developments do apply to non-unionized workforces as well. So it's important that you're aware of those. We're going to talk about where labor policy is headed under the Biden administration. We're going to talk about some cases and issues to watch out for under the Biden era board. And then we're going to wrap up by talking about proposed amendments to the National Labor Relations Act. The statute's called the Protecting Right to Organize Act, or the PRO Act, PRO. So some changes at the NLRB. Currently, there is still a Republican majority. There's the 3 Republicans are listed here. There's 1 Democrat and there's 1 vacant seat, which we do expect Biden will appoint a Democrat to. So that would be a 3-2 majority for Republicans. But as you can see, one of the Republicans' terms expires this August. So just a little over 4 months from now. So at that point, we expect Biden to appoint another Democrat, and they would have a 3-2 majority at that point. As with similar to the EEOC General Counsel, Biden actually immediately fired the NLRB General Counsel and the Deputy General Counsel, which is something that we haven't seen a president do in recent history. It was pretty controversial. And an appointed career NLRB staffer has been the interim acting general counsel since that time. The acting general counsel promptly rescinded 10 general counsel memoranda that were propagated during the Trump administration, saying that they were either inconsistent with the purposes of the National Labor Relations Act or no longer necessary given the board's decisions in interpreting the applicable law. So we can expect, with a Democrat installed as general counsel, some pretty immediate pro-labor shifts in both investigations and enforcement priorities at the NLRB. Once the Democrats gain the majority on the board itself, they can implement much more sweeping changes as well. And so that's going to happen just later this year. So some cases to keep an eye on and some issues that the NLRB may change positions on. The NLRB, for those of you who follow it, has really been swinging back and forth with different administrations. And so it's very interesting to see, with the Supreme Court, for example, we see changes over long periods of time, but we don't see the very frequent swinging back and forth with each administration on a large number of issues. So the NLRB is a bit more unique in that regard. But here's the issues that we think it might now be swinging back on, especially once the Democrat board is in place. So the Boeing company case, this determines the standard for illegality of company policies. And this is an example of something that would be important both for unionized and non-unionized employers. So it says that it implemented a balancing test that weighs the employer's business interest in the policy versus the employee's right to engage in concerted activity under the NLRA. So this is something we've seen swing back and forth. The case that Boeing overturned was Lutheran Heritage. In that case, it said that a facially neutral work rule could violate the NLRA if employees could reasonably construe it as preventing them from engaging in protected concerted activity. So under that older rule, the more pro-employee rule, we saw some general counsel memoranda on handbook policies that said a lot of interesting things, like you can't say in your handbook that employees have to be professional and considerate at all times, because sometimes when you're union organizing, things get a little rough and rowdy, and that's okay. That's protected activity under the NLRA. But prior to that, most employers in their handbook had language saying you have to behave in a professional and considerate manner in the workplace, or something similar to that in their handbook for years. And all of a sudden that was now illegal under the NLRA. And then with Boeing, that in 2017, under the Trump administration, that swung back and said, no, it's a balancing test. You have to weigh the employer's interest in having a rule like this versus the employee's rights under the NLRA. And so that's something that may swing back. If it does swing back, you will want to make sure that you check your handbooks and make sure that it's in compliance with whatever the new standard is. This is something that the NLRB, even though you're not a unionized employer, could pursue an enforcement action against you. Another one is Caesars Entertainment, which held that employers do not have a statutory right under the National Labor Relations Act to use their employer provided email for non-work union organizing purposes. And that's something that may swing back as well and give them the right to use the company's email system for union organizing purposes. And if it does swing back, you'll want to make sure that if you have any handbook policies applying to use of the email system for non-work purposes, that it's compliant with whatever the new case is. Apogee Retail held that it was legal for employers to have workplace rules that required employees to keep open investigations confidential. After the investigation's over, it was kind of an individual scrutiny of whether or not confidentiality was still required. But during a pending investigation, it was legal for employers to say, you have to keep this investigation confidential while it's pending. And that's something that may swing back as well. That's something that we've seen a lot of back and forth on over the years. PCC Structural sets forth a standard for defining the appropriate bargaining unit in a union campaign. So the current rule is that the group has to have a community of interest that's sufficiently distinct from the interests of employees who are excluded from the union. The prior rule held that the union's description of the unit is presumptively appropriate and that it's the employer's burden of proof to show that anyone excluded from the unit has an overwhelming community of interest with the employees in the unit. And so that was a much more pro-employee standard that permitted things like micro bargaining units. It also made it easier for unions to win elections. And to have fragmentation in the workplace where similar groups of employees are represented by different unions, or some are represented by unions and some are not, which is obviously much harder to manage from the employer's perspective. So that's something that may swing back as well. MV Transportation implemented a more favorable standard for employers to make unilateral changes to the collective bargaining agreement. That changed the standard from a clear and unmistakable waiver to contract coverage. So that's something that may swing back as well. Valley Hospital addressed continued dues after the collective bargaining agreement had expired. That case held that it wasn't required. That's something that may swing back as well. Some issues to keep an eye on going forward. Separate and apart from the cases, as far as their enforcement guidance, general counsel memorandum, their enforcement priorities, election and procedure rules. So pre-Trump, under Obama, there were some quickie election rules enforced, and that made it much easier for unions to prevail in union organizing elections. It really shortened the period of time that employers had to campaign and respond and try to give employees information in response to what they were hearing from the union. And so in a lot of these quickie elections, employees would just get kind of the union side and not much information from the employer about some of the downsides of becoming unionized. And so that made it much more difficult for employers to prevent unions from successfully campaigning and coming into the workplace. The Trump administration did make significant changes there. Based on Biden's statements, it's very likely he's going to go back to the quickie election system. And if you're in an industry where you think union organizing is something that you might face, it's really important to be very proactive and to have a plan in place and to be prepared so that you can respond immediately once you get a union petition. Because if you wait to put those plans in place till you get the union petition, you already have a very short period of time between that, knowing that there's going to be the campaign and the election itself. And so you don't want to spend any of that time planning and figuring out what to do. You already want to have that done. So you can use that full time to communicate to employees and make sure that they get all the information from both sides so that they can really make an informed decision on whether or not they want a union to come in. Because obviously the union's not going to tell them what some of the downsides of becoming unionized are. They only hear a lot of promises and all the upsides of becoming unionized. Joint employer status. This is something that we've talked about throughout because this crops up in so many different areas. It crops up in discrimination cases. It crops up in wage and hour cases. It also crops up in the NLRB issue. When are employers joint employers for purposes of NLRB? And here, the standard had returned under the NLRB to a direct control standard, which is a very narrow pro-employer standard. That is something that we may shift back, and we may see the Biden administration take a much broader view on what a joint employer is. For independent contractors, a similar sort of thing. Under Trump, we saw a very narrow view of who were employees and a broad view of independent contractors. Under Biden, we expect that to swap and for them to take a much more narrow view of who's appropriately classified as an independent contractor. Graduate student union organizing, under Trump, the position was student workers are not employers for the purposes of the National Labor Relations Act. Their primary purpose is educational and not employment-based. And so therefore, they couldn't organize or become unionized. That's already been withdrawn by the Biden administration. That was withdrawn in March of this year. So that's something that, for those of you who are in higher ed, that we may see much more of. We might see many more union campaigns for graduate students in particular. Okay, so that brings us to the PRO Act, which is just a massive piece of legislation. It was introduced on February 4th of this year. The NLRA has not been amended in a very long time. And this really just completely revamps the NLRA and makes, as the slide says, sweeping changes. It's actually more than 50 significant changes to the National Labor Relations Act. So obviously, if this gets passed, we'll do a separate webinar and provide very in-depth information about how that's going to impact you as a unionized or as a non-unionized employer. But for today, I would still like to go through an overview of what some of those big changes are, just to let you know what may be coming. So this is obviously a top priority for unions throughout the country to get this bill passed. It would make a lot of very pro-union changes to the National Labor Relations Act. It did pass the House of Representatives on March 9th. It's not anticipated to get 60 votes in the Senate. So the question is, again, do they get rid of the filibuster? Do they change the filibuster in some way to try to get this through? But President Biden has made it clear that if this passes, he will sign it. So really the only question is whether or not it's going to make it through the Senate. As I've mentioned throughout, this bill does make changes both for unionized and non-unionized employers. So even if you're non-unionized and you don't pay a lot of attention to the National Labor Relations Board because a lot of the issues don't impact you directly, this would, both in terms of handbook policies, as well as, if you do face a union election, what that would look like. So some examples of some things of a handful of the things that this law would do is it repeals the Taft-Hartley right to work provisions. So that effectively overturns all the state right to work laws for all practical purposes. There's also makes changes as far as card checks and no captive audience meetings. What that means is it eliminates a lot of the employer's rights to challenge the cards signed by employees petitioning for a union and question their validity. It also restricts an employer's ability to have what are called captive audience meetings, requiring employees to come and hear the information provided by the employer about some of those downsides to unions. So right now, employers can require employees to come to those meetings, and this would change that. It would permit secondary boycotts, which is a very significant change. What those are is, currently when unions boycott, they boycott outside of the employer, but they're not allowed to do a secondary boycott and go and have boycotts, protests outside of the employer's customers, outside the employer's vendors. This act would permit those boycotts, which, obviously from the employer's perspective, you really don't want your workers, that gives them a lot of leverage that they don't currently have, because it can be very damaging for a company's goodwill with the customer if there's people protesting outside that customer. There's provisions about the gig economy and protections for gig economy workers. There's expansions of so the union could require employers to provide employees' contact information to the union during the election campaign, and employers would have to turn that over. The PRO Act also prohibits mandatory arbitration agreements from employers. This is an example of a significant change for non-unionized as well as unionized workers. We've seen a lot of court cases in the Supreme Court over the last 10, 20 years that have been very pro-arbitration. There's a federal statute called the Federal Arbitration Act, and the Supreme Court has interpreted that very broadly and very permissively, and has held, in general, that arbitration agreements are very much enforceable. And that provides employers with a really great option. If they don't want complaints publicly filed in federal or state court making allegations, they can require employees to sign arbitration agreements, requiring that any disputes be handled in confidential arbitration. It's important to keep in mind that those agreements don't and can't prevent the employee from filing administrative complaints, like with the Division of Human Rights or the Equal Employment Opportunity Commission, but those complaints are generally not available to the public. Whereas when a complaint's filed in federal court alleging that some higher up at your company engaged in sexual harassment or racially discriminated against someone or discriminated based on age or disability or whatever the allegations are, it's not uncommon for local press to pick up those complaints and publish an article saying this company is accused of all these horrible things before the company even really has a chance to get into the case and defend itself. And companies that are looking to avoid that sort of negative press really rely on these mandatory arbitration agreements. And that's something that this act would prohibit. You couldn't have those sorts of agreements. It also prohibits permanent replacements for boycotting workers. It broadens the U.S. Department of Labor's persuader regulation. That's a pretty big deal because that makes it much harder for companies to be able to seek labor advice from their attorneys, from other outside consultants. It creates all these additional reporting requirements and obligations that just create an additional hurdle to you as an employer from seeking out advice about how to deal with a union organizing campaign, for example. It also, another big change, allows for private lawsuits for NLRA violations. Currently, if an employee thinks that the National Labor Relations Act has been violated, they have to file a complaint with the National Labor Relations Board. It's similar to going through the Division of Human Rights process. There's an investigator who looks into it, comes to a determination. The employer, either side can appeal that determination, can go to a hearing in front of an administrative law judge. If a party doesn't like the outcome there, they can appeal it up to the National Labor Relations Board, but it stays within the National Labor Relations Board. Here, an employee could now go to court over National Labor Relations violations. And so that's, a much scarier thing, especially with attorney's fee provisions, and that just makes it a much more expensive thing to deal with. And not surprisingly, it loosens the joint employer standard as well, which, as we talked about from the outset, can have a lot of implications in a lot of different contexts. If you are a franchisee or a franchisor, if you have related entities, parents, subs, affiliates, or even entities that aren't, officially related on your org chart, but have common management or common ownership, or if you are a temporary employee agency, or if you use temporary employee agencies, there's a lot of different ways that this can arise, and there's a lot of ways that this can have an impact, for example. So if, you're not unionized, but another entity is unionized, the union could challenge and say, well, you're a joint employer too. So every employee at your company that fits within the unit definition for this union should also be, as a joint employer, should also be within this unit, and challenge whether or not you can keep them out because they're employed by a separate entity. It also, another significant change, just to wrap things up, is the frontline leaders currently are viewed, so if you have a shift supervisor or an assistant manager or something like that, who's kind of a frontline worker who performs work with the workers, but is also kind of the supervisor, you can classify them as a supervisor and they're not within the unit. This would actually make them employees and not supervisors under the act. And so they would have to go into the units as well. Okay, so a lot that we've covered today. There's a lot that we see coming down the pike. Obviously, with any significant changes, we'll be doing updates and offering new webinars as they come out. But some other ways to stay updated with some free resources from Bond is we do have our labor and employment blog. You can go to that and sign up to get email updates whenever something new is posted. We post when there's any major developments in New York or federal law, employment law. We also are continuing, we started this a year and a half ago, but we've been doing a free weekly coronavirus update. And that's not exclusively employment, although a significant portion of it is. And that's a great way to it's every Tuesday at 12, it's 45 minutes. It's a great way to just stay on top of what's going on with coronavirus, because we found that every week there's changes, there's developments. And so that's just a free and easy way to stay on top of all of those developments. We also post recordings of those as well. If you miss one, you can watch it after the fact. And that link is where you can go to register for that. We also do free pop-up webinars for clients on new issues as they develop, as well as our biannual breakfast briefings and our annual workplace seminar, which is open to clients and non-clients for a fee. So those are just some resources I wanted you all to have. Today we are recording the webinar. So if I've gone too fast or if you've missed anything, just let Kathy or me know, and we can provide you with a link to the recording. And you should have all received copies of the slides as well. So I don't see any other questions. So it looks like we can wrap up a bit early, but I will stay on for a few minutes. So if anyone wants to, type in another question, just feel free to do so. Otherwise, thank you all so much for coming, and I hope you all have a great day.